Um, I'd like to look at the American judicial system. Um, I'm going to pick the wrong the wrong template here. I like to put my picture up in the middle. I'm not sure where I'm going to put it this time. I guess it'll go over on the right. I'll just shrink it down. I think that works. Anyway, looking at, I believe, chapter 3 of the American judicial system, looking at jurisdiction and venue. So what this will do is compare state and federal judicial systems. I begin with a slide that has my hero, Abraham Lincoln, as a young, I believe this is a picture of him in the Illinois legislature. Probably one of the greatest Americans of all time and one of the great trial lawyers. But his advice to his clients, which included the Illinois Central Railroad, he was a very prominent railroad lawyer, and they're finding documents of his in Japan, all over the place. A friend of mine worked for the Lincoln Library and said even she was overwhelmed at the number of documents they found. They're still finding them in Illinois courts. But his recommendation to clients was to avoid litigation at all reasonable costs. Litigation is just filled with uncertain outcomes. At best, you get a level playing field, two good lawyers, and it takes you completely out of your productive range. You're sitting there fighting a battle over something that occurred 2, 3, 5 years ago, and the litigation itself can last for 3 to 7 years, depending upon whether you go to the Supreme Court of the local state or all the way to the U.S. Supreme Court. The latter two are very unlikely, but if it's a major piece of litigation, it's pretty easy. You can get in there if this is a chance for them to either clearly state law to make the law finer. Oftentimes, you will get it. Don't expect to get to the Supreme Court, very limited. But I throw you a couple of ideas in thinking about whether you really want to litigate. Are you better off just offering someone a refund or a rebate on a secondary product? No, there's nothing wrong with that product. Would we do something else? A lot of retailers find that returns kill their bottom line. But maybe we're better off saying, yeah, okay, I can see why you're unhappy here. Rather than litigate it, let's offer a rebate. At the same time, there are a lot of people who take advantage of that sort of a system and are always looking for free money. I put down here, refuse to negotiate or honor claims. There are certain businesses that have developed a pretty hard reputation for, they don't give in to anything. One of the ones that I'm aware of is Walmart. Has a pretty tough reputation on, you get hurt in store property, it's pretty likely they're not going to believe it or pay you a penny. And as I was an attorney, I had a lot of people calling me. I had one guy that called and said, I was going shopping and I noticed a spilled Coke. I came back 20 minutes later and it was still there and I slipped in it. Now, folks, what's the liability there? He knew it was there. The fact that they didn't clean it up in 20 minutes is kind of his word against theirs to begin with, but he knew it was there and he still slipped in it. If you can see it. So I basically said, look, how bad hurt were you? And, it turned out he'd missed a day of work. It's not worth litigating from that standpoint. So, Walmart kind of is also like, you fall in our store, it's rarely our fault. Other entities take kind of the same road. Most supermarkets have these claims all the time. People will drop stuff on the floor, then slip in it. They get this all the time. So there's a lot of specious claims. Bi-State bus, as soon as there's an accident, they lock all the doors so nobody can rush to get on. Anyway, maybe something different. Let's look at the basic idea is that state courts get almost everything. All right. You can look, here's a short list of everything that the state courts handle: contracts, torts, civil wrongs, that's auto accidents, workers' comp type of things, although workers' comp is in its own administrative category, property disputes, domestic, divorce, child custody, criminal. Almost every, it used to be that there weren't very many federal crimes. That's changed a lot of late. But it used to be that was all a state matter. There were a few federal crimes such as treason, and that was it. But that's grown tremendously. And then this may or may not seem very important, but probate, the ability to hand on property from year to year or after death, which impacts a lot of businesses because business leaders die and they usually leave successful businesses, and people want pieces of it. Or they leave a pile of debt and we've got to come back after it, or somebody dies without paying off a debt to a business. So probate's a big part of it, almost all in state court. Federal courts have limited jurisdiction, and generally their jurisdiction is limited to there being a federal question. That is, there is a statute that gives a legal right or arguably gives a legal right to a person, and they could sue under it. For instance, an EPA violation that causes cows to get sick might be a federal question. The other one is diversity of citizenship. And this plays in a multitude of ways for businesses, because businesses which operate across multiple state lines are subject to suit in states where they don't think they're doing business, but where their product maybe winds up or where their idea winds up. Generally, what we can get is in a diversity of citizenship case, we might have the plaintiff of a state like Pennsylvania suing a business in Missouri, but suing them in federal court or suing them in state court in Pennsylvania. Well, this is the last slide in this set. I'm jumping ahead a little bit. We may want to remove this out to federal court, assuming we're going to concede on jurisdiction, which is also another problem. But we're generally dealing with a state law question, and we need diversity of citizenship. All right. So a Missouri entity against a Pennsylvania plaintiff we would have. Oops, I got a typo here. There should be another residence. Oops, shouldn't have done that. Let's go back one. I got a typo, sorry. I may or may not fix that. Sometimes I just leave them. And so what we're saying is that the federal courts exist in part to prevent kind of forum shopping or making it impossible for somebody to defend themselves. We could recognize that a Virginia resident might sue somebody from Massachusetts, and the Virginian would tend to be favored. We find in federal court a lot of that sort of local favoritism goes away. There also are some special courts that exist in federal courts. One of the biggest examples is the bankruptcy court that is given power to the federal courts in the Constitution of the United States of America. We also have questions on federal taxation. There are, at least the way I remember it, there are two systems. There's the tax court system itself, which is an arm of the Department of Treasury, or we could file in district court. And so accountants, you may want to look at district court if you think you've got a real world beater question and the tax court is rubber stamping some old decision. The district court can be a way to maybe get the tax courts to revise. It's sort of it's a step up from the tax courts, but then a lot harder to litigate there. The rules are harder. It's a very different system. If you've got a client who's constantly in the tax court system, you may want to stay there, but hopefully you don't have a client who's in the tax court in either one of these problems. But chances are you're going to see some litigation at some point in your life, business life. And one of the ones you're almost all going to see if you're running a business is bankruptcy. That's hopefully not your own, but it may be the bankruptcy of your customers, your suppliers, or others. So know that you'll probably be in federal court. We cover that very late in the semester. Generally, let's look at the organization of the two systems. I've put the state on the left as I look at it, and the federal system on the right as I look at it. Most states, New York is a major exception. The circuit court is the low court. The Supreme Court of the state of New York is the trial court. The appellate court is the higher Supreme Court. And there's Supreme Court Appellate Division is the appellate court. But if you're not going to New York, that may not be material. But understand that a lot of the eastern courts kind of are separate. I'm looking more at what we have out in the Midwest, where a circuit courts, and I didn't pull this up in advance. I should have. See, I can pause this. Well, I tried to pause and go to the internet, but something's wrong with my system. Generally, what we have is circuit courts, which are organized. We have, like, the city of St. Louis is its own circuit. The county of St. Louis is its own circuit. But right next to us, I believe it's Franklin, Washington, and Montgomery counties are another circuit. I think they're the 10th circuit. And so inside these circuits, what we will find is we have a lot of divisions. So we may have a child support enforcement division, a probate division, a contract division, a trial division, criminal trial division, et cetera, et cetera, et cetera. We usually have associate circuit judges, many of whom hear kind of the lesser materials like small claims is oftentimes given to an associate circuit judge. Periodically, though, there's a circuit judge overseeing the whole thing. The circuit judges stand for election. The associate circuit judges appoint the circuit judges appoint the associate circuits. The circuit judges have to be reelected about every 8 or 10 years, depending on the state. Associate circuit judges generally continue at the request of the court. They're usually given at least 10-year contracts simply because it's a big disruption to move in and out of judgeship. You can't hire a guy for a year and then tell him, oh, you can't do this. They've told all their clients, hey, I'm going to go on the bench. I can't really help you anymore because it's a conflict of interest. So it's not fair to that individual. But they may give them a heads up that, hey, your 10 years are up. We're going to give it to somebody else. And why they're going to do it. Same sort of thing happens in the district courts federal. The district courts, like if we look at, we've got the Eastern District of Missouri, which is basically, I can't remember, I know Illinois is, I didn't practice much in Missouri. I only did Eastern District. There may be just an Eastern District and a Western District, so headquartered in, guess what? St. Louis, but there's a federal court up in Hannibal, and there's another federal court down in Cape, and or maybe in Sikeston, and they hear cases that are kind of germane to that area. But they've got judges. The judges are nominated by the president and then approved by the Senate. Those judges then appoint magistrates who act sort of like associate circuit judges. The district courts always have a bankruptcy division. They also have civil and criminal trial divisions. and you can always opt to have your case tried in front of a magistrate, which in some cases, for civil cases, that's the only way you're going to get to trial, because the full judges are so busy with cocaine and criminal conspiracy type material, you can't get into the others. Both have an appellate court. Okay, in the state, most appeals are a matter of right. The same generally is true in the federal court. You've got an appeal as a matter of right. You usually have very short times in the federal court, 10 days from judgment in order to appeal. You get maybe 30 days in order to appeal. In most appellate courts, there's a lot of civil procedure ways to lose your claim, like, you may have to file a notice of appeal in the lower court. I'm going to appeal your decision, Judge. You may have had to bring a lot of post-trial motions, other things that we'll cover in a different lecture. If we appeal from a judgment and not everything goes to jury, and I've kind of glossed over whether, let me take a moment. Sometimes, particularly if you're in a sophisticated business, you're better off in front of a judge than in front of a jury, because a judge is more likely to understand you, and it's chances are they're a member of the country club, and most of their associates are business people. That's kind of a cynical look at it, but it's a reality that might be talked about less freely. Maybe I shouldn't be putting this on the internet, but juries, however, are wonderful at divining facts and getting down to the truth of the matter. Judges hear so many different cases that sometimes they get a little jaundiced and they can't clearly hear things. But you will find that if you are, sometimes if you're accused in a crime, you may want to discuss with your attorney whether you're better off having a judge-only trial or having a jury trial. Certain businesses, are like doctors, lawyers, are fairly successful and don't necessarily have, they have more public envy than they have public regard. So they have to be a little careful. I'm a big fan of juries. I tried 13 jury trials, 6 and 7 record. But was I perfect? No, I'm no Abe Lincoln. But I thought the juries really did a great job, and they pay close attention because this is their one or two chances to operate in the legal system. The appellate courts don't take in new evidence. They operate only from the record. That is the record, all the transcript of all the testimony, all the depositions, all the discovery, everything else. And they're kind of in a highfalutin fashion. You guys are all going to report appellate court decisions to us, and hopefully it'll give you some idea. I don't want to drone on and on. I've got a few more slides that I want us to cover. We generally get a panel of 3 judges on the first appeal. If things don't go our way, we can petition for an en banc review, which means we want to have all the judges on this panel, on this appellate court, come in and hear the case. Well, as you can imagine, that's not something they're eager to do. They're only going to do this on the most significant cases. For instance, when the Affordable Care Act or Obamacare was making its way up through the circuit courts of appeal in the federal system, I believe the Sixth Circuit and maybe the D.C. Circuit both held en banc appeals, but the balance of them, they said, no, we trust this 3-judge panel, move it on. That case eventually, of course, made it to the Supreme Court because it was major litigation that impacted every American. Healthcare across the board, sweeping legislation, big issues in terms of congressional power, presidential power. That's the kind of case that's going to make it to the Supreme Court. At both the state and federal level, you're going to have about 110 to 120 cases heard by the Supreme Courts in each. each is also going to get about 5,000 petitions to have cases heard. Therefore, you have a, what is that, a 1 in 50 chance of being heard there. Pretty low. It's got to be to make it to the Supreme Court of the state of Missouri or Illinois or Iowa or Arkansas or Kentucky or Tennessee. It's got to be something that really has statewide impact. The fact that he got the blender in a divorce case, not going to make it there. But the fact that we had our kids were split. Dad got the girls, mom got the boys. Well, this could be earth-shaking in the state of Missouri. We may want to look at this carefully and analyze it so that we can tell every court out there, here's how we think in today's society you should do child support kind of deals. A case like that's not going to make it to the Supreme Court of the United States. The Supreme Court of the United States has an original jurisdiction in things like territorial disputes. So if the Missouri River wanders and cuts into Iowa, is the part that it cut now part of Nebraska, or does it remain part of Iowa? There's about 10 to 20 cases that the Supreme Court has discretion on, and the balance of them are almost set by the Constitution. Fairly similar situation in the state courts. The Supreme Courts hear all of the capital crimes. So anybody sentenced to death does not go to the appellate court. They go straight to the Supreme Court. And if you think that through, that makes sense. The Supreme Court of the state of Missouri has 7 judges. They tend to be the pinnacle of the profession, and they're from all over the state. So they're a mixture of, 2 from Kansas City, 2 from St. Louis, and 3 outstate, or give or take. It's probably not quite that. It's probably actually more balanced toward outstate, but they're going to get a better feel for. And I think they even do it a little bit regionally, that there's always somebody from up around Hannibal and somebody up around Moberly, et cetera, or around Columbia, Jeff City area, blah, blah, blah. I'm not real acquainted with the inner workings, but that's generally how this kind of stuff works, is that if we look at Illinois, we're going to have at least 3 judges from the Chicago area, 1 from Peoria, another one from downstate, primarily Edwardsville or Belleville, but not always, and then 1 from kind of central Illinois, and you're done. And then 1 maybe who's at large or way down south or whatever. Anyway, so both courts, getting to the Supreme Court is a challenge, besides which you may not really want that. Just because you're in court doesn't mean you win. A lot of people think, I'm going to beat you in court, but, it's, maybe think about it as the Patriots playing the Patriots. If we play the Patriots against the Patriots in football all the time, we're going to get about a 50-50 outcome. It's not like the Patriots playing the Rams and we're the Patriots. No, it's a very different setting. So last thing I've got to cover, and I really meant this to be a lot shorter. I'm sorry. There's just a lot in the law, and I know a fair amount of it, but I want to look at jurisdiction and venue. Jurisdiction is the power of the court to speak law to an individual. Well, in order to do that, we have to be able to grab that individual and bring them into the court. I can't be sued in Hawaii since I've never been there. All right? Now, if I reach out into Hawaii and grab, get a business going with somebody in Hawaii, I should expect that, hey, if it goes south, that person may sue me in Hawaii. All right? But if my, I buy something at the local Home Depot, it goes bad, I'm going to expect that I can either sue Home Depot way down in its headquarters, wherever that is, or I can sue them locally. And I'm probably going to sue them locally, and I'm going to be able to get jurisdiction over them because they got a bloody store here and they do a lot of business here. All right. So some of the things we look at in jurisdiction: residency. Do both parties reside there? Case closed ordinarily. Did the occurrence happen in that jurisdiction? Again, case closed ordinarily. All right. Is there a sufficient nexus? Does this jurisdiction, does Missouri have enough contacts with the litigation and the parties that it can hold it? So, as we began to travel more interstate, the railroads, other stuff, we began to get away from more and more of this just purely local law. It used to be that a farmer would rarely leave the county they were in, right? They wouldn't even go to the state, maybe they go to the state fair, blah, blah, blah. Well, we began to see cases where people began to travel more, businesses began to expand their reach, and we get Erie, which may be Erie Railroad, I can't remember it. Erie v. Tompkins is a very famous U.S. Supreme Court jurisdictional case, and it basically announces the doctrine of minimum contacts. You have to have at least some contact with the state in which the case is filed for that state to exercise jurisdiction over you. You'll find almost all of the language of Erie versus Tompkins in state long-arm statutes. So this is an example of a state law arising out of a Supreme Court of the U.S. decision. Similar thing is that Roe versus Wade caused a lot of abortion statutes to be rewritten to comply or to test the compliance. The book makes an interesting reference to internet jurisdiction. If I'm doing internet stuff, I might think, well, I can avoid jurisdiction by locating in Shanghai or Singapore. Well, good luck with that. If you are reaching out into an area to try to get business there, you've established jurisdiction over yourself. Okay? So let's look at this Zippo model real quickly. Passive is, I've got an informational website, so maybe it's a blog, or I've developed one myself with some financial planning things. I need to get back to it and redo it. But it's basically meant as an informational website. I'm not trying to sell any product. I'm trying to give advice. Now, an interactive one is maybe if I added some features where, people input data, and then I give them advice based on data and charge them a fee. I've probably moved over to the integral to business model side. The interactive is more case by case. Are we trying to provide a free service? No questions asked, or are we trying to make a buck off of it? When we're trying to make a buck, we're starting to look at, have I reached out to you wherever you are? If I've done that, I've been intentional and therefore maybe subjected myself to your place of residency's law. The next section, and this isn't bad actually for me to cover this quickly, I think, is venue. And here we're looking at what is the proper place to hear this. So maybe if we back up to circuit courts, does it make sense that an automobile accident should be heard in Kansas City when it happened in St. Louis? All the doctors are in St. Louis, and at least one of the two people resides there. Yeah, it was somebody from Kansas City traveling through St. Louis, and they'd rather have it held over in Kansas City, but they may be tough toenails. We may be able to go, Judge, this is just, it all happened here. All the witnesses are here. The police officers who will testify, everybody else will be here. Let's not let them forum shop. There's also a doctrine called forum non-conveniens, which basically looks at this sort of thing we've had, particularly in the toxic torts. the asbestos stuff, some of the talcum powder. We maybe are suing in certain jurisdictions that are actually removed from all the parties. But it's because, say, the city of St. Louis gets some subject matter expertise, as it says at the bottom. In that kind of case, we may go there. Well, the defendant may go, hey, wait a minute, they're forum shopping. We really shouldn't have it. Let me jump to something else, which is kind of the impartial jury, less so in civil cases, but very much in criminal cases. For instance, the kid who just got convicted in Charleston, South Carolina, I believe they tried to move that case out of Charleston. And what they argued was there's no way a jury there could be impartial. Well, it turned out that they could find a jury there that actually knew very little about the occurrence and could be impartial. Because of the reaction of the church members, it really didn't get a lot of press. Those people all begged forgiveness for the guy who killed all their parishioners. Remarkable people, just remarkable people to take God's word that deeply. Anyway, this is venue is about what's the best court to hear it. Okay. So one place we see some real forum shopping is in domestic relations. Periodically, the woman or the man might take the kids and go somewhere like back to grandma's house where they know that grandma and grandpa have this great reputation, including with the judges, and everything's going to go their way. So it's always there. I hate to cover it this quickly. We spent about 2 weeks or more on this in law school, but guess what? We spend about 3 hours total on almost everything we're talking about here. I did throw in some final thoughts. These may not be politically correct, but businesses, particularly interstate businesses, need to be aware of the opportunity to remove cases to federal court. One advantage we can get there is oftentimes, as a business, we may be being sued in an urban district, big giant corporation, not that favorable ordinarily to urban juror population. And so we may be better off with a federal jury, which would have a mixture of urban and rural jurors, because rural jurors don't tend to be quite a socialist, if you will, in their thinking. Oh, capitalism's bad. No, it's just not that way. There are some negatives to federal court. If you're litigating there, you generally have stricter rules of court. Now, sometimes the companies like this because they've got the lawyers who are real good at it, and so they love to bring the plaintiff's lawyers who aren't necessarily good at federal court in. Generally, federal court discovery is broader than is available in state court, although since we're applying state law, some of the judges are really up on local state law, and sometimes the state discovery is extremely limited. Missouri pretty much lets each side have their own investigation, and they don't have to share it with the other side until after deposition, thereabouts. The general reason for going to federal court is less local favoritism. We do have some federal judges who do tend to be somewhat imperious. I think we may need to know that. Some of the federal judges aren't that acquainted with local law. They may be much more attuned to federal law. And so, these are things where you need to consult with good lawyers who know these systems pretty well. I hope this helped explain this a little bit, or at least give you some introduction to this field. Thanks. Bye.